Welcome to Publish It Group Talks. I'm Lauren. Our studio guest is Muhammed Vally. Welcome, Muhammed.
Thank you, Lauren. Good to be here again.
It's nice to have you back.
Good to be back.
So the aim of the channel, for those who are new to listen, and if you haven't heard our previous recording that we did, I encourage you to go back and have a listen, because this is building on a series where we're going to be looking at intellectual property law and also understanding patents, trademarks, copyright, registering designs, and just sort of looking at it very holistically, but also making it easy for laymen to understand and when to know now's the time to invest in this. I have a good idea. How am I going to go forward? I'd like to tell the new listeners, and listeners may have been listening to the channel previously, that this channel is a platform where we want to live up to a motto of arrive smart, leave smarter. We educate, inform, and inspire our audience. The inspiration from the show comes from conversations I have, a network of experts and professionals who have a lot of information to share about bringing them onto this platform and allowing them to share that information to the audience. Muhammed is an intellectual property lawyer. He's a registered patent attorney in South Africa, dealing in all aspects of intellectual property law, both locally and abroad, including patents, trademarks, copyright, registered designs, and litigation. He's also been an attorney for the last 8 years and has a degree in law and biochemistry. Muhammed, I'm going to hand the, so to say, mic over to you.
Thanks,
I know that the audience have responded very positively to the first show. Could you just tell us a little bit more about intellectual property?
Sure. I think, and thank you, Lauren, for that introduction. The last time that we had spoken, we spoke in broad, general terms about the motivation behind the establishment of intellectual property rights and the need for protection for purposes of commercialization, deriving a profit from what you're doing. For us to now progress to the next natural stage is to basically categorize these rights. Talk a little bit about what these rights are, so that one can now, from our last conversation, select the appropriate form of intellectual property protection. And as we progress further, we'll go into each of these categories and talk about each of these rights in greater detail. But for current purposes, what is intellectual property? That is a serious question that we need to answer. And there's a very nice definition that intellectual property rights, or IPRs, are rights that protect the creations of an author's or an inventor's mind. So you can see that it is squarely within the confines of the creativity of a person, and ultimately it is based on a reward theory. The theory goes that for rewarding somebody's creative input or their ingenuity, the state, in consideration for the disclosure, will provide them with a time-limited monopoly in some instances for purposes of protecting that right, and for the inventor to have the right to completely exploit the subject matter that falls within that right. So let's go quickly into the different forms of IPRs. The first one, and the most important in my view, simply because of its all-encompassing nature, is that of patent rights. What are patent rights? These are rights to an invention. The Act doesn't define what an invention is, but we give it a purposive interpretation. It's basically anything that may have been invented, whether a product or a process, a method of doing something, that can be subject of patent protection. So if you now figure out a way to make a spare part for a car using a process that hasn't been done before, and the process is either quicker in succession, so you're pumping out more product per minute, or it's cheaper. These are benefits that one can identify as the value proposition of your business model, and you can protect that process. If it's simply a product, you've created something that is in a tangible form that either nobody has done before, or maybe it's an improvement on an existing product, it qualifies or may qualify for patent protection, subject to what we had discussed earlier, the extrinsic and intrinsic registrability requirements. So that's the first form of intellectual property rights that we can consider. The next form of intellectual property rights is if we can give it a natural flow, trademark. You've got this product or you've got this process and it falls under your business, and you want to give it a name so that the general public can associate that name with your company. It's a signpost. So if somebody says, listen, I want an Apple device, immediately you associate Apple, the product, with the company Apple. But it need not have the same name. You could adopt two different names. So let's say, for instance, you've got a shelf company that's called Super Quick 123 Pty Limited. But you've got this nifty product that you've decided to call Orange. And everybody associates the product Orange as the innovator in your space for purposes of entering the market with something that is new, that's innovative, nobody else has. The general public is going to associate that trademark with that product and indirectly as a signpost to your company. It builds up a reputation, a trade reputation that distinguishes or serves to distinguish your company from that of your competitor companies. Another form of intellectual property rights that would be pertinent to our listeners is copyright. This we'll spend a bit of time on because I feel that this is the first sort of, if I can call it, feedstock.
Yeah, like what is copyright actually? It's so...
Correct.
What does it mean exactly? Because you get copywriters and they're like, we're not the guys who put the C at the end. You're the guy who puts the C at the end.
Those copywriters perform a completely different function, obviously. But copyright as a form of intellectual property right protects certain forms of categories of works that's defined under the Copyright Act. For example, literary work. So that would include anything in a written format, whether it's a product specification that you've drafted as an author, or a book. You're the next best-selling novelist. The book, the content of that book qualifies as a literary work, and you can protect it from somebody else exploiting it without your say-so. But it doesn't only extend to literary works. It protects photographs as a different form of copyright or work. It protects paintings and statues. Computer programs, very important in our age. There's different codes, source code and object code that you can have copyright protection in. And the Copyright Act deals with the creation of these rights as a non-registrable right. Instead of going to the patent office and going and filing a formal application for the protection of your copyrighted work, you simply include a little disclaimer at a suitable place in your work. For example, if it's going to be a book, typically on the inside front cover, you're going to have a little copyright disclaimer. The year in which the work was first created, for example, if you wrote the book in 2012 or you created the work in 2012, that would be the opening gambit. The name of the holder of the copyright, so for example, Muhammed Vally, all rights reserved. That's the simplest form of copyright disclaimer, which basically tells the notional reader or the person who's viewing this work that there's an intellectual property right form that someone intends to rely upon in excluding others from exploiting that work to the exclusion of the owner. You get a fair amount of variances across the board, but the effect is the same. Some people would say copyright reserved, all rights reserved, no part of this book or work may be reproduced. It is all perfectly in order. It simply tells the viewer or the reader that this is an intended protected work.
So I can just safely put that on, insert the symbol with that disclaimer without having to do anything else. It's just...
Correct. And that at least establishes the right. Now, whether or not the right qualifies for copyright, well, that's subject of a different consideration. So, for example, you have to be an author, you have to be a qualified person, meaning a resident of the Republic, and the Republic is also a member of certain international conventions that give recognition to these forms of works across several different countries who are also members to the same convention. And that the work must be an original work. So it doesn't necessarily mean, as we discussed very briefly under the title of patents, that it has to be a work that nobody else has done. It could be similar to somebody else's written piece of work. But as long as you're the author and you haven't utilized anybody else's work in the creation of yours, then it stands free. It stands as a copyright.
What if they say, but this book is so similar to such and such an author, you must have extracted information from there in order to have written that book, and you're saying, well, yes, I've read that author, but I didn't extract that information to write this book. Where would that leave you?
Well, the consideration would then be, to what extent have you relied upon the book in creating your own work? You could get into a dependency situation where your derivative work, having been based on somebody else's work, would require a license for you to commercialize, simply because you've taken a significant amount of the benefit in and to that work, and you've created your own work. That you have your own copyright in and to your work, that is unquestionable. But whether or not you might infringe a pre-existing third party's right in your derivative work, that is also a consideration. So ultimately, it's a matter of fact. We're going to have to consider both pieces of work, and we would have to look at what is the essential part that has been taken, what's the substantial identity that may have been extracted. And that really is the test. I know that people have come across many of these myths that 30% or more of the work may qualify as an infringement, and if you take less, then
I hear
it
that
doesn't.
a lot, yeah.
That isn't the test. It's completely different. So rather avoid the Google test and go and see an attorney. Take your work, take the original work or the claim for infringement, and get a proper opinion on whether or not you've in fact trampled on somebody else's territory.
And I think that copywriters actually have to be very careful, because they really do need to come up with their own stuff instead of extracting a lot of the stuff they find in order to compile information, because they tend to be more of the creative writers.
Correct.
That this would apply to. Even if they're hired for a company, they would need to also be very careful that they don't use similar copy to another company's ad or to a jingle that would apply a certain thought in someone's mind. You were saying, with a word invokes a thought, and that's what you want to do with your brand. You want to be like, oh, orange, yes, that's that cleaning product, or,
Correct.
That's that extra, fuel I can add that will make my engine run more efficiently.
Precisely. So it's all about the manner in which you project your IPR right, or you define it within your business, that will give you that identity or that reputation that gives you the competitive advantage over everyone else. Because at the end of the day, this is a business psychology. You're simply harnessing the available tools that's available under statutory forms of protection for purposes of advancing your business. That is really what it is. You want to make sure that your notional customer knows about you and is not going to confuse you with your competitor down the road. You want to hold your own identity. You want to have the ability to say, I've written the text for this advert, or I've taken this photograph that we've utilized for purposes of this advert, and nobody else can, in fact, simply copy and paste it. Remember, we live in a digital age, and I think the inventor of the Control-P and Control-C function is turning in his grave if he's not alive or with us anymore, simply because many people would probably be swearing him, and at the same time, people would be congratulating him for such a simple function. But that function can lead to problems if you're not careful.
And it's also hard to trace the source of the photograph. So you Google, as we know is dangerous, and
Yes.
you're Googling sunsets. And you're looking for an image that you can use for a client because they don't have a sunset picture and they've got a guest lodge. And so you find a sunset picture and it's a great quality, but there's no trace back to who the sunset picture belongs to. And so you put it on your artwork, you send it to print. Would you credit that as unknown, or would you say anything about it? Would you leave it and hope for the best, cross your fingers? And
Yeah, look, if you've gone through the rigmarole of trying to identify who the holder of the copyright in and to that work is, assuming that there's copyright in the work in the first place, and you're able to demonstrate the paper trail, I don't think that somebody can come along and rush off to court and claim significant damages from you because you've attempted to try to limit your exposure from a litigation risk point of view substantially, which is a good thing. But if you are able to find that there is in fact copyright, that may be in a little disclaimer at the foot of that picture, or it may be a tagline from a website that says copyright may subsist in this form of work, please do not copy this without the written permission of the author, and you don't, then you're opening yourself up to some sanction, serious sanction from the courts.
Who actually owns the rights of the picture if you're a fashion photographer, say for instance, and you've been asked to shoot a series of photographs for a company, and you shoot the photographs, you edit them, you supply the company or the individual, and that company or individual says to you they would like all the original open files, the raw files that were unedited, and you say those actually belong to me, you don't have rights for them, but the client's commissioned you and they've paid you. Who has the right in this situation?
Yeah, in that instance, the holder of the copyright would actually be the person who commissioned for the work to be conducted, provided that the agreement between the parties, most important of which is that the photographer gets paid. That would be the owner of the photographs. But as a point of departure, typically the author of whatever work is under consideration is the owner of the copyright in and to the work. If payment doesn't transpire for whatever reason, then the author, the original author, being the photographer himself or herself, can lay claim to ownership of that photograph. It's very similar to a normal commercial transaction, where, for instance, I want to buy a car from you, whether under an installment sale transaction or payment at a later date. I reserve ownership until such time as you've paid me, and that would be the trigger for ownership to pass. So it's similar in that sense.
How long is copyright valid for?
Well, as a rule of thumb, the different forms have different timelines, but one can typically measure, dependent on the work, the life of the author from when the work was first created. So the copyright disclaimer would be a good indication, plus 50 years after the demise. Just as a general rule of thumb, different works have different terms. Not substantially different, but at least you're able to measure whether or not you fall squarely within a possible claim for infringement if you're going to utilize that copyrighted work. But obviously, once the term expires, then that copyright no longer subsists and you are free to go and copy the work.
So if I found a high-resolution picture of Van Gogh, one of Van Gogh's arts, one of his pieces, and I printed it on a wallpaper, and I went to a print shop, and then I put it in my lounge, he's been dead for longer than 50 years. Am I allowed to do that?
Yeah, I would say that you are free to do that, unless there's somebody else who might hold certain rights. It falls within the derivative nature of copyrighted works. So if somebody went and created that high-resolution picture as a derivative work, they may qualify for copyright protection. But it depends on the facts.
As long as I'm not selling it, I suppose.
Yeah. There is an exclusion, an important exclusion that I should mention in relation to copyright, and that is if you are copying a work, for example, a textbook or something of that nature, simply for research or own purposes, it ought not to attract any sanction from the copyright holder. But the minute you you start commercializing the work, then you're going to attract sanction. Look, nobody's going to litigate for 1 or 2 rand. It's where you are making significant inroads to a monopoly that you're not entitled to. That justifies the cost of litigation or the prospect of damages or harm that may be occasioned by your conduct is either the type that cannot be remedied or it's the type that will bring severe harm to the copyright holder. Then you can expect litigation.
If I make a little tub of jam and I create my own logo and I put it in the local shop, can I copyright that at all?
Yes, you can. Your label. Certainly not the ability to sell jam. Anyone is entitled to that. But if your label, your logo, your writing, and everything else associated with the label, apart from the obvious things such as your barcodes and whatever else you might want to put in there that you get from different people, or your Proudly SA logo, if it's a locally produced product, that you can't lay claim to any monopoly to. There you enter into agreements with the various role players who are responsible for that. But in relation to your product name, you may be entitled to trademark protection there, to the appearance, the drawings, the photographs, or how you have created your label, the design elements relative to each other, that could qualify as copyright protection as well. But remember, lots of people don't do the design themselves. They typically outsource that design to somebody else.
Yes.
And if the intention is for you to simply use a designer as a Rosetta Stone, in a sense, where they take your idea and they translate it into a material format, that should be regulated by contract up front. You want to tell them, listen, here's my idea. I want you to reduce this into a material form. I'm going to guide you. I'm going to be the person giving you instructions on how the label should ultimately look. I'm going to tell you which color or which combination of colors you're going to utilize. And there's no creative input from the designer, him or herself. Then the holder of the copyright in and to that work would be the person instructing the designer. But if someone goes along and says, listen, I want a food label done and it's for peaches or jam, please go and do something for me, then the creative input resides with the author or the designer themselves. And that's why regulating the agreement or the relationship between the parties up front would be a very good thing to do. It's a good idea to try and have the rights defined before the work is created, before the money starts rolling in. Because if it's going to be a very successful product, I can guarantee you the fight is going to start.
Yeah, and so many designers get briefed to design a logo or a marketing idea around a product that the client has no creative input in. They charge for it, they hand it over, and there's always that question of how much of that do they really own, in a sense. And is it still theirs? Are they part of that? Should there be additional remuneration? But what you were saying earlier, and I'd just like to bring this point back, is you made a point of saying the individual briefs the designer, tells the designer what color to use, what they want on the logo, what shapes they want them to draw. So interesting that you say that, because so many clients say we have to think for the designer, like the designer is a drone and it's a completely stupid entity, and they moan about that.
Right.
Where you're saying that that's actually a very good thing, that they're briefing the designer so specifically because then they own the intellectual rights of that. They're telling them what they want, the designer's creating it as per what they want. That's a bonus for the client, actually, where they treat us like it's a negative.
Absolutely. And it all boils down to where do the rights reside, with whom. Not everybody knows how to use graphics programs such as Adobe Photoshop. I mean, it's a complex program if you're utilizing it for the first time. It's not as easy as Word. And some people actually consider Word to be difficult. But if you go to someone simply for their skill and their knowledge of Photoshop and how to use whatever tools are available there to convert your idea into that material format or the electronic mock-up of what you're trying to achieve, then the designer has no claim to any ownership. But then, you can regulate that upfront in an agreement. If the designer says, you know what, I'm not going to charge you for this. I want an equity stake in your company, or I want a reasonable royalty for whatever products you sell as a result of this product being commercially successful for the life of the product or for the life of copyright, which way they decide they want to go. That is also perfectly in order. But have that conversation right up front so that you don't have the battle in court later. You know what they say, good attorney isn't one that wins your battle in court. It's the one that avoids court altogether.
I like that. I think it's very relevant.
Yeah,
That's a
and
good point.
your agreement for purposes of conducting the work, that could incorporate clauses relating to assignment. So even though the Copyright Act might provide that in these instances the author would be the owner unless it was commissioned by a certain person, let's deal with that up front. Let's have it stated that as the author, I hereby assign upon payment, which I confirm whether there's an annexure or evidence by a receipt of the work that I've produced, and in consideration for the payment, I hereby cede, assign, transfer, and otherwise make over all right and title in and to this work over to the holder of the rights. But there's certain provisions of the Copyright Act that's known as model rights. And I think this is important for designers to remember, because sometimes your creativity is second to none and you're very proud of your work and you want the world to know, listen, I designed it. It was my hand and my creative thought that lent some of the get-up or the projections to this design that's so successful as a marketing tool to attract future clients. Here the model rights, despite the assignment of the rights to the holder that now resides with the person who commissioned for the work, the ability to lay claim to being the designer is protected by virtue of Section 20 of the Copyright Act, which is the model rights. Essentially, it's a two-pronged thing. It's the right, it's the right to paternity, so it shows origin. I am the author, I was the person who designed it, even though I'm not the owner. And it's also the right to preservation, where you have the right to tell anyone who subsequently comes into possession or ownership of the work that they cannot mutilate the work. So you have a say over that for purposes of preservation, and I think more importantly for this industry, recognition.
Yeah.
So if I do a little booklet to show or showcase the kitchens that I've built in the past, so that I can demonstrate to future potential clients how good my work is, I should be entitled, in terms of the model rights provisions on the Copyright Act, to display it. But you obviously want to also negotiate upfront with the person who's instructing you that you will or you won't do so, you reserve the right to do so that they don't turn around and say, but I own it, so how can you do this? Let's go to court and go and slug it out. Have that conversation up front. It's so important for purposes of communication to deal with these issues.
It is. It's very important. And I like your advice regarding the designers saying to the client, sure, I won't charge you for this, but I would like a 1% or 2% or just a small royalty fee off this product, because it also then creates that opportunity of, instead of designers saying there's no work, is take on these projects, these creative projects. As you said, you get a lot of clients who do come to you, and we spoke about this off the air, and they've got amazing ideas, and you're going, wow, they're spending all their money legally. They get to a point where they've got no money to market these ideas and they fall flat. But if these ideas are just pushed out into the market, they are hugely profitable, and they just need an agency or a designer or a very capable creative to make it possible for free, let's say, but at a small commission when the product picks up.
100%. In as much as people are creative in the establishment of IPRs, I think that creativity can lend assistance to a business case. So like you rightly point out, money is always a concern. Cash flow is a massive issue. If you're not pulling in money and people are not willing to spend money, how do you then participate in competition with everyone else, especially if you are SMME? These are issues that you're faced with every single day. So in your creativity, you should also look at how to derive revenue in a creative sense. And what you can do is, like we said earlier, enter into an agreement at risk where you conduct certain work on behalf of someone, and in their commercialization efforts, if the product is successful or if it's taken to market, share in the royalty with your designer, because then it creates a passive form of income for the designer.
And loyalty.
And loyalty, correct. There's so many things that you can regulate that can assist both businesses in forging ahead. And this is a value add that I like to offer to my clients, where I can see someone with a creative idea and I know someone who I've done a bit of commercial work for, and there's a potential synergy between the two. I like to introduce the two of them, because then it simply opens up opportunities. Remember, you've got the right. You've established the right, but you don't necessarily have the means to take the product to market quickly enough to derive revenue quickly enough to support whatever else your business requires support in. Some people have expertise in creation, other people have expertise in supply chain know-how, and that is a different form of IPR, which we call confidential information. We'll touch on it in one of the later programs. But in having this database of clients that they can simply take a product, feed it into, and have that product feature on the shop's shelves sooner rather than later is something that may be unavailable to your creative designer who's otherwise got a fantastic idea, a fantastic product for that matter.
This is a great opportunity for agencies, and I would imagine if agencies and smaller agencies too, if that was something that they were doing, we would actually know about this. But I've never heard of this before, and I think it opens up a huge can of worms. I mean, I can see designers sitting there like salivating and thinking, oh my gosh, how do I get hold of Muhammed? I need to send him my CV. I'm a really good designer. I need some of those clients.
No. We simply do introductions. We don't do employment. But the idea is a wonderful one because it simply opens up opportunities where previously doors are shut. Remember, a designer going to a big corporate with the next big thing in his hand may simply be unable to pass the frontline staff. Do you have an appointment? No, I don't. Well, come back when you do. But, in as much as they're doing their job, and they should be doing their job in that way and not keeping the door open for every Tom, Dick and Harry to come through, you want to have the ability to filter what could be the next big thing, make the necessary introductions, and let the people go and make money.
Yeah.
It's a value add. It's not something that attorneys normally do. It's simply a gap in the market that I've identified.
Yes.
And in this way, you can actually create a business case.
This is job creation.
Correct. And
this
it's
is
empowerment.
Job creation.
It's empowerment by utilizing my existing skill set and client database to introduce clients to each other.
Yes.
Obviously with their consent.
Yes.
I don't go and throw around business cards.
And also you would want to work with reputable agencies and individuals that would offer a good service. They're already established in the market. It would be synergistic as well because as those agencies deal with clients, those clients' products also need to be registered. So it's creating that network around what we do and also realizing that we're so diverse in what we do, yet we can complement each other perfectly.
Exactly. And with this sort of opportunity, instead of a big company or a small company saying, hey, this thing is quite good, how do we copy it? How do we get around it? Instead, you're creating the conversation of, okay, so let's work together. Let's see how we can both bring this product to market and make it beneficial for both of us. And it just reduces the risk of fighting later. And it actually augments what these laws, these IPR laws, are intended to augment, and that is creativity, to encourage innovation, to encourage people to think out of the box and to bring products to market. I mean, South Africa has a wonderful history of great inventors, great products, and we should aim to stimulate and encourage that so that we can again feature on the map, global map, as a company that is not only rich in resources but also rich in ideas. We live in an information era. Everything is digitized and information is at everybody's fingertips. Let us feature amongst the world countries that we are a country to contend with.
I agree. Thank you. I'd like to just wrap it up by saying to the listeners, please don't bomb Muhammad's email address with all your CVs and your amazing work. You're welcome to also contact us. I think this is definitely a very educational, informative, and inspirational episode. It's given our listeners a lot to think about. They've arrived smart, they've left smarter, as our motto says. Thank you so much. For those who are new, you can contact Muhammed on LinkedIn. You'll also find his information on our platforms. You can email us at hello@publishergroup.com. We'll give you additional information on our website as well as on our various channels. And you can also find us on Twitter and connect with us on Twitter. Thank you so much for listening, and thank you, Muhammed, for being here.
Thank you, Lauren, and to the listeners.
And guys, send us your questions. We're interested in what you've got to say. Have a great day.